So my name is Jeff Morgan. I am a co-hosting today for Dad Talk Radio, and I'm here with Melissa Isaak. Everybody knows Melissa Isaak. Melissa, thanks so much for being here.
Yes.
So one of the things I wanted to ask you, when you go into court, I don't see people objecting enough. Can you give some hints on how you should be objecting to certain things?
Yeah, we see that a lot as attorneys in the courtroom. You know, the rules of evidence are there to make sure that everything runs a certain way. I mean, there's ways that evidence should be introduced, and there's ways that evidence shouldn't be introduced because it can hurt your case. It could be biased or it could be unreliable. So the rules of evidence are very important for your attorney to utilize, and objections are amazing. You guys, you use your objections. You know, there might be some information that the other attorney is trying to get in that is false. That is biased, that is unreliable, and use your objections. You can keep that out, you preserve your transcript, and then you've got a better chance on better odds of success in your case. So the biggest thing that we see in court is leading, okay? The other attorney starts leading. Now sometimes I let him go, like, your name is Jeff Morgan, yes, and you live at 123 Salem Road, yes, and you have a 12-year-old son, yes. I don't object to stuff like that because it doesn't matter, the judge already knows. And sometimes if you object to every tiny thing, the court gets aggravated, like, okay, come on, you know. The court will say, okay, sustain, don't lead your client, but at the same time, just be smart with your objections. So, you know, if it's your witness, right? You call your witness, and it's a direct examination, which means you can't lead. All right. So if I'm going to ask Jeff a question, rather than saying your name is Jeff Morgan, isn't it? That's a leading question. And I say, sir, state your name for the record.
Jeff Morgan.
Jeff Morgan. All right. So one of them is saying your name is Jeff Morgan, isn't it? That's leading. Sir, state your name for the record is not a leading question. So there's some things that when you get into the child custody cases, the other attorney might get up and say, an inappropriate leading question, and say, now Mr. Morgan, your wife, Mr. Morgan, you abuse your kids, don't you? Objection, that's a leading question. Anytime that the answer is usually yes or no, right, it's kind of a leading question, so you got to be careful with that. So you object to judge that's leading, assuming facts, not in evidence, right?
Okay.
So judge will say, you should say, right, sustained, don't lead your witness, right? So, Mr. Morgan, you're aware of the allegations that are made against you today, are you not?
No.
You're not,
no.
All right? Well, Mr. Morgan, I'm going to show you what I have marked Exhibit A. This is what your wife filed with the court. Do you recognize this document?
No, never seen this before.
You've never seen this before. Well, Mr. Morgan, it's been filed with the court. You're telling me that you've never seen this document before, even though it's stamped that this is an official court document?
I've never seen this before. That is correct.
All right. You can say at that point, you say, Judge, I'd like the court to take judicial knowledge. This is in the court record, that this is indeed a document that has been filed with the court. Or what you could do is you could then go to the other party, right, and you could authenticate it through the other party if you needed to. But usually the courts will take judicial knowledge that this is indeed an authentic court document.
Okay.
Or I could give it to you and you do recognize it. Say, Mr. Morgan, do you recognize this document?
Yes. Yeah, I recognize it.
Okay. Mr. Morgan, could you read paragraph 3? Paragraph 3 might say that the former wife alleges that Mr. Morgan picks his daughter up by the ears and shakes her profusely. Okay? Mr. Morgan, you read that allegation? Yes, I did. Okay, so rather than me saying, well, Mr. Morgan, the court said the allegation is that you picked your daughter up and shook her by the ears, right? That would be a leading question. So you use the court documents, you use the rules of evidence, because everything has to be done the right way. Because this is the thing, I know that we'd all like to believe that these judges, they study the record before you get in there, right? Truth be told, I've seen many judges reading the record while you're giving testimony.
I'm glad you said that, because I've been in some of these cases and I'm like, this judge has not even seen the stuff. He's reading it and he's taking time, and you're paying for this at the same time.
Yes, you're paying for it at the same time. So, and of course that's frustrating for us as attorneys because we've put so much time into drafting these motions. You attach exhibits, you file it with the court, and you might say, hey, this is an emergency, and then you may or may not get a hearing, expedited hearing, but when you get there, the judge for the first time is looking through stuff, so it gets quite frustrating, right? But from a evidentiary standpoint, anytime you want to get a document introduced or anytime that you want to reference something, you make sure your documents are authenticated. They have to be real documents, guys, because it tell you what, sometimes people tend to just get in Microsoft Word and create some stuff that's just off the fly, that's not true. So you want to make sure all those things are authenticated. But back to leading, all right? You don't want to let the other attorney lead when it matters, okay? It doesn't matter, your name is, Jeff Morgan. I'm not going to stand up and be like, objection, he's leading. Obviously, this is Jeff Morgan. Okay, so when it matters, don't let the other attorney lead, because they can get stuff in. They can act, it's almost like testifying for their client, right?
Right.
So I see this all the time. So opposing counsel might get up and say, and ma'am, you're terrified for the safety of your son while in the care. Objection, judge. This lawyer can't testify. He's leading. Sustained. Right? So the proper question would be, ma'am, tell the court some of the concerns that you have regarding the safety of your child. Well, when my child is in the care of Mr. Morgan, I'm afraid that she's going to get picked up and shook by her ears, okay? But it has to come from the witness. It can't come from the attorney, okay? And what I have seen, unfortunately, I've seen some attorneys that try to testify on behalf of their client, but guess what? The client's testimony sometimes is different from the attorney's. Don't let attorneys testify, guys, because sometimes when they lead, they're making their record, and if you don't object, it goes on the record. It's rare. Some judges will intervene and say, stop, don't lead the witness, let them testify. But that's very rare. Most judges, if you lead and you're not supposed to, they're going to let you lead. Okay, they're just going to let everything go on the record.
Can I ask a quick question here? So you're a pro se litigant.
Okay.
And you're on the stand right now. As a pro se litigant, can I object to the question then?
You can.
Okay, so,
yes.
But, okay, so I'm on the stand and I can say, objection, Your Honor. Even though you're asking me the question,
yes.
Objection, Your Honor, this is leading.
This is leading, yes.
But if I'm represented by an attorney and the attorney that misses it, I can't say it, objection, Your Honor.
Well, you can, but usually the judge will stop and say, well, let your attorney do the objecting.
Okay.
But if you're a pro se litigant and your attorney's not objecting, I'd go ahead and say, Judge, that's a leading question. You guys make your record. Any way you can make your record. I wouldn't let that go if my attorney wasn't doing their job.
Right, yeah, I got you, okay.
Definitely.
Go ahead.
Right. So, you can't lead on direct, but when you do a cross-examination, you can lead, okay? So let's say that opposing counsel, calls her client, and it's the former wife, and she's asking questions, not leading questions. I can get up, I can cross-examine her, and I can lead her all over the place. I could say, ma'am, you testified that you were afraid that Mr. Morgan is going to pick your daughter up by the ears and shake her. You do that, don't you, ma'am? You're the one that picks her up and shakes her by the ears, right? You do that. No, I don't. Now, I can put her on the defensive. I can make her answer yes or no questions. Right? I can, because I'm on cross-examination. Attorneys don't make enough. They don't take advantage of cross-examination. You guys, you can take someone to task, you can take them to school on a cross-examination, and your attorney needs to do that. So a cross-examination, you get in there, and you should have a lot of evidence refuting, okay? And you take that, you throw it in front of them, right? This is your story. This is your time to tell your story. This is what happened. No, I'm not done, ma'am. Wait till I'm done with my question, okay? Don't let the witness should never run that courtroom. If you're an attorney and you're especially on cross-examination, I'm direct too, but you run that courtroom, especially on a cross, because you can lead them all over the place, right? Now, where you can't lead is when if it's outside the scope of the direct. So let's say that I call my witness, I call Jeff. And Jeff gets on the stand, and all I ask about is say, tell me about your house, Jeff. Well, it's a 3-bedroom home. My daughter has her own bedroom. We go through everything. What's the routine? What's the schedule? What's the bedtime? Tell me how you guys get to school. And then I say, Judge, I'm going to pass the witness, and I sit down. Well, then the other attorney gets up and says, Jeff, you have such and such medical diagnosis, don't you? I object. That's outside the scope of direct. I did not talk about medical issues. Don't let them go there. Don't let them do that. Because remember, they have them on cross, right? So they can inject all this stuff in on cross that I didn't bring up on my direct examination. You make them bring that up on their direct so they can't lead him, okay? So don't let, now the other attorney can cross-examine, but if it's outside the scope of direct, you object to protect your record.
Okay. Okay.
Because what you don't want is you don't want them to lead your witness. You want as little leading as possible. So don't let them lead outside of what you brought up to the court. Does that make sense?
It also seems to me that at the same time that this is a very strategic way to plan. Okay, go ahead.
It's very strategic. Okay. Now also, you guys hear a lot about hearsay. Okay, hearsay is an out-of-court statement made in court. Okay, for the truth of the matter asserted. That's very important. Okay, so we hear all the time, right? I got a text message from my former wife. She called me a piece of shit. Let's say, for instance. Okay, Judge, I object. That's hearsay. Well, I'm not offering to show the truth of the matter asserted, right? I mean, it's almost a slang sort of thing. So you can get that in because I'm not trying to prove that you are literally right. That. So, but if it's an out-of-court statement, and this is where most lawyers mess up, even if it's made by the litigant, you think, well, Judge, no, I can ask. This isn't hearsay because they're sitting right here. Doesn't matter, you guys. If it's an out-of-court statement made in court for the truth of the matter asserted, it's hearsay. Okay? So you can still bring it up for the fact that it was said. Okay, you can bring it up for the impact that it had on the person who the statement was made to. Right? So a lot of times people can say, hey, look, you know what, my witness couldn't make it, but I got this affidavit. It's hearsay. It's a statement that was made out of court that you want to give to the court for the truth of the matter in the statement. It's hearsay. So you guys, I hear all the time, my witnesses can't come, but I'm going to be there with affidavits. I got 10 witness statements. I got 10, character references. They're not allowed. They're not allowed in. So you show up for court thinking you got this arsenal for all this character witnesses, and you walk it and you have nothing. Okay? So that's hearsay. Anything out of court, made in court for the truth of the matter asserted is hearsay. All right? So your attorney should object to any hearsay whatsoever. So sometimes if we have cases where CPS is involved or GHR is involved, and the client is testifying and say, and then the social worker came to my house and she said, boom, object, hearsay. The judge should say, sustained. You catch them before they say it. Now, some attorneys, they get it out and they say, Judge, I object. I'd like that struck, strike it from the record. Judge might say, okay, stricken. Judges can't unhear things, okay? You can't really unring the bell. So as soon as they say, social worker Smith said, object to hearsay. Okay, don't even let it get it out of their mouth. All right, so that's a very, very, very huge, very common objection you need to make. All right, let's see. You guys, your attorney shouldn't let you get harassed by the other attorney. Okay, so we hear a lot about gaslighting within our community. One spouse might gaslight the other. I tell you what, Jeff. The professional gaslighters are the lawyers.
Oh, right? I've seen that. Absolutely have seen that. Yes.
So here, you're on the stand, and the other attorney gets up, because you can be sort of aggressive on cross, right? And they start hammering and hammering. You did this, and then you did this. Now, if they don't let you answer the questions, your attorney should say, Judge, first I object. They're harassing my witness. Let my guy answer the question before he moves on to the next question, okay? So your attorney should also object if you're being harassed, if you're not letting you answer the questions, okay? So now they can say, I just need a yes or no. Did you or did you not say X, Y, Z? Yes or no, okay? And I do that a lot. Ma'am, yes or no? Yes, but I move on, okay? Because I just want that yes. Now the other attorney can come back and say, Miss Isaac asked you a question, you answered yes. What did you mean by that? They can follow up, okay? Don't let your witnesses sit up there and just ramble and ramble and ramble. That's being non-responsive, okay? So as a good attorney, you want to control that witness. Now, the hardest thing as an attorney, I think, is to control a bad witness. And that's where you rein them in with your questions. You say, ma'am, I'm going to ask you a question that requires a yes or a no. You ask your question. If they start rambling off, you cut them off, say, Judge should be non-responsive. This is a yes or no question. And if they say, well, I have an explanation. No, their attorney does that, Judge. They can follow up if they want to on cross. I'm asking a question right now, okay? Or they can redirect. This is my question. So too many people let people just ramble on and on and on and on. Yeah. But I would say this, most times if you ramble, you get yourself in trouble. Yeah. You're always better off just to answer the question that's asked of you.
So let me interject here just for a moment, because I've been doing some court watching, and I've been watching some of these things take place, and I come out of there and I think to myself, number one, if you want to know the truth, don't go to court. You're going to get a story.
You're going to get a story.
You're not going to necessarily get the truth. But then the other thing is, I've got a friend, and he has an attorney who's trying to use the good old boy network. So he's not being aggressive for him, but he's going to use his relationship with the judge to influence the outcome. Which, of course, that's not the purpose of the court to begin with. But this is the way he's going to do it. It's the good old boy network. I mean, it's kind of like Boss Hogg and his minions, and I don't know if he's Boss Hogg or the minion or who he is. But anyway, there are times that I've said somebody should be objecting, somebody should be saying something or following up the questions.
Yes.
And the attorney says, I have no questions. Pass the, and I'm like, what?
Yes.
So
yes.
How does a witness protect himself when he's being abused? Because I know when you say yes or no, well, the answer is not necessarily a yes. A yes may be a correct answer, but give the exact wrong impression.
Yes.
So is there anything that I as a witness can do on my own to say, Judge, it's not a yes or no answer?
Yes, you can say, Judge, I'm sorry. I can't answer this with a yes or no. I'm sorry, I cannot. There's too many moving parts for me to answer this with a yes or no. If you're respectful to the judge is most of them say, okay, I'm going to give you a little bit of latitude here. Just answer the question and give us an explanation. Okay, so definitely.
Okay.
Yeah.
Okay, that's good, because I've seen this happen and I've thought, this is not right. What's being done is the truth is being spun with a yes or a no question.
Yes.
So, okay, thank you so much for that. Okay,
exactly.
Continue on there.
Okay.
Great,
right.
Thank you.
So another one is refusing to answer. Sometimes I've asked a question and the witness said, it's none of your business. Okay? Ma'am, I have to ask you one other time. Will you please ask the question again? I need you to answer my question. That's not your business. Judge, would you please instruct the witness to answer the question? Okay? And the judges, I've never had a judge tell me no. The judge say, ma'am, you need to answer Ms. Isaac's question. Okay, so it's hard to deal with a difficult client sometimes, but the rules are there. You get into the rules, you can really put on a good case. Right?
Yeah.
Another one. Now, you guys, sometimes judges they enter these pretrial orders where witnesses have to be disclosed by a certain date, or experts have to be disclosed by a certain date, exhibits have to be disclosed by a certain date, and a lot of times people don't do it. Lawyers don't comply with that. So, if the other attorney gets up and they say, Judge, I have here what's marked Exhibit B, and you say, wait a minute, Judge, can I see that? I don't have that. Other attorney shows it to you. Judge, I object. That was not disclosed to me. It doesn't conform to your pretrial order. I object to its admissibility. All right, Judge say, well, Mr. Smith, did you give that to Miss Isaac in discovery? Judge, I just got it 2 days ago. I didn't have time. Why didn't you send it to me 2 days ago? I'm like, my email worked 2 days ago. I didn't get that, Judge. Don't let anything in that doesn't comply with the court's orders. Right? That's another one. Too many attorneys let that go. Witnesses, same thing. If you have to disclose witnesses and they didn't disclose the witnesses, you say, Judge, I'm sorry, I've got the witness list here and Mr. Smith is not on it. If they didn't supplement their discovery, I'm apt to object to the testimony of Mr. Smith. Okay? So a lot of times judges will say, I'm sorry, it wasn't disclosed in discovery, but if it's used for impeachment purposes, you could probably still get the witness on. Okay? Because the thing is, if you're my opposing counsel, there's no way for me to anticipate everything you're going to say in trial. So I can say, Judge, if you object to my witness, I could say, Judge, at the time, I didn't have, Mr. Smith on my witness list because I didn't know that Mr. Morgan was going to do X, Y, Z. So for impeachment purposes, I need to bring Mr. Smith in for this limited purpose. Judges usually say, okay, for impeachment purposes, I'll allow it.
So that is very interesting here. I've been sitting as a court reporter. Well, not as a court reporter, as a court watcher. And the attorneys will start to call me as a witness.
Yeah.
And is that permissible? And I mean, basically, the last time I was in there and they called me as a witness, and they kicked me out of the courtroom. Because, is all of that stuff on the up and up? I mean, to me, it seemed to be a little bit unethical, especially because they knew, they just didn't want me to report on that.
Yeah, I agree. I agree. So, is that on the up and up? I'm going to probably say probably not. It's a strategy to get you out of the courtroom.
Yeah.
Can they do it? The rules allow for it. Is it ethical? I mean, I don't think so. But is it allowed? Yes, because witnesses, if you're a witness that's going to testify, you're not allowed to stay in the courtroom for there to be the other testimony.
But you don't even know that I mean, for example, if somebody calls you as a witness during the course, I'm like, well, wait a minute, I didn't even know I was here to watch this case, not to become a witness.
So, the attorney can make the objection at that point. It's up to the judge. But is it on the up and up? No, it doesn't sound like it's on the up and up at all. Is it allowed? Is it allowed? It's hard to say. And in Texas, I don't know. I'm not a Texas attorney, so I don't know exactly what the laws are in Texas. It doesn't sound like it's on the up and up. Though.
Okay.
It doesn't.
Okay. Good enough.
Yeah. So let's see. So utilize your scheduling orders. You send discovery. You have to update your discovery. It's an ongoing request or whatnot, and ask for those things in discovery. Ask for their exhibits. Ask for their recordings. Ask for their documents. Ask for anything that they're going to introduce a trial. Ask for that, because if they don't give it to you, then you can object. You object to its admissibility, and try to keep it out altogether.
Okay.
So you can really utilize the rules of evidence and your objections in the courtroom to increase your odds of success.
Okay. So perhaps you can address one other thing with me: contempt of court. So the witness is saying, "I refuse to answer." The judge, instruct the witness to answer the question. Answer the question, whatever. I'm still not going to do it. And the judge can find the person in contempt of court for something like that. And
Absolutely.
Tell me a little bit more what contempt of court means. And I hear contempt of court being thrown around all the time. And sometimes, to be honest with you, I think, well, if you're a normal moral person, you should hold this court in contempt. But that's my opinion. But anyway,
So contempt of court, I've had witnesses that I was questioning, judge instructed them to answer, they still wouldn't answer, and the judge said, well, maybe you'd like to sit down in jail until you're ready to testify. Okay, so I've never actually had somebody get put in jail for that, but the judges have threatened that. They can do jail or monetary sanctions, or if you're in contempt for not basically complying with discovery, judges can give you a default if the other side isn't cooperating. So there's different methods, different ways that they can hold people in contempt, but largely I find it's a way that for them to coerce you into doing something that they want you to do.
Gotcha.
I've been threatened with contempt because
I couldn't imagine that ever taking place.
I was threatened with contempt actually quite recently because I was making my record. The judge said that's enough, and I said, with all due respect, I'm going to make my record. I continued to make my record, and he said, would you like me to hold you in contempt? And I said, whatever you need to do, I'm going to put this on the record. And so I did. I made my record and sat down, and wasn't held in contempt, but we went on with our hearing.
Yeah.
But yeah, and there's different types of contempt. There could be direct contempt where the judge actually witnesses, indirect contempt, which might be like a non-payment of child support that has nothing to do with the court observing anything. But
so that's very interesting that you say that, because the issue of child support, we have people that go thrown in jail because they don't pay their child support.
Yes.
And I still think that really what they're doing, they're throwing them in prison for debt.
Yes.
Which is against our state constitution.
Yeah, I agree.
But they take the contempt of court. It's just a matter of, I'm going to use this word instead of that word. But I think that they're illegally incarcerating people.
I agree. There's no debtor's prison except for when it comes to for child support. I agree. And I would love to see a big class action lawsuit. I mean, an attorney in every state really tackling the child support issue.
And we have one right here that's ready to go after. So
that'd be wonderful to do a class action lawsuit, because men are getting their driver's license suspended, they're losing their jobs, and of course you're sitting in jail, you can't pay child support at all.
Right.
There's no relationship with your kids.
And then you have a record and how you're going to go back. Yeah, it's really
affects your credit. Yeah,
absolutely. So I think we're pretty well. Are we wrapping up here? Okay, so anyway, Melissa, we've got to wrap up due to time. Thank you so much for taking the time here. It's always good to see you again. Every time I see you, I learn something from you, and I hope that in the future that we can do the same thing again.
Awesome.
Thanks so much. Appreciate it. Thanks so much.